Good morning, everyone. I'm Don Bautista, the Executive Director of AC Friends of Court. We help British Columbians complete their legal forms. And these days, we do so using an online platform. Every day, our intake crew take on requests from the public. And what we have noticed is a palpable increase in the level of stress that self-represented litigants have. And so we decided what we wanted to do was to create a series of one-on-one interviews with the heads of our courts, as well as the chairs of tribunals, to provide them an opportunity to talk to you directly. Oftentimes, the leaders they tend to be unseen and unheard. And hopefully we will be able to change that because Dear British Columbians, the series, allows them to speak to you directly, unfiltered. So there are three things we're going to try and do with our interview today. The first is to inform you of the planning and the thinking behind their planning. Secondly is to allow our interviewee to tell you, the public, what they're doing to even the playing field. And thirdly, to share their reflections on what they're learning now that they've been sort of adjusting for 2 months now, and to see what is going to be coming up in the horizon. Our guest today is the chair of the Workers' Compensation Appeal Tribunal, Andrew Pendray, and he has agreed to share with you what they're doing to help you, the public, when you file your appeals with them, as well as to assure you that if you want to file applications with their tribunal, that you can do so without having to worry too much that if you can't afford a lawyer, it's still okay. Good morning, Andrew.
Good morning, Don.
Before I ask you the 4 questions, I wondered if there was anything you wanted to just say to your viewers.
Well, I think that since you mentioned that often our tribunal heads and court heads are sometimes unseen and unheard, maybe it's useful to give sort of a little bit of a background of what our tribunal is about. So the Workers' Compensation Appeal Tribunal, WCAT, as we call ourselves, everything's an acronym. We're an independent appeal tribunal, so we're not part of the Workers' Compensation Board. We're the second and the final level of appeals for workers' compensation in British Columbia. We hear appeals about people's entitlement to compensation for injuries, occupational health issues, whether they're entitled to wage loss benefits, healthcare benefits, permanent disability benefits. But we also hear appeals regarding things like occupational health and safety. So when employers receive fines, we hear that type of appeal as well as where people suffer adverse employment consequences, such as being suspended or terminated for raising occupational health and safety issues. So we cover a broad variety of areas in workers' compensation. We try to hear our appeals in an efficient manner and provide people with really high-level decision-making. And as you mentioned, we want to be accessible. And so I think that's some of what we're going to talk about today.
Yes, we are. Well, on to my first question, Andrew. Admittedly, it's only been 2 months, but the 2 months have been very intense. And I am curious what lessons you've taken so far that sort of impacted how you and your officials go on about your business in terms of adjusting to the new normal so that you can help the public.
Sure. Well, I think our lesson has probably been the big lesson for most people is that we all can be more flexible than perhaps we thought we could be. So for us, one of the biggest things is, and we'll probably touch on this a little bit more, but 40% of all the appeals that come before us, we do by in-person hearing. So suddenly having to adjust to all of those scheduled in-person hearings and figure out how we're going to proceed with them, because we didn't want to delay people's hearings. We know that the people are generally waiting to receive compensation benefits if they're successful. So we don't want to slow that process down. So we had to adjust rather rapidly in that regard. We also had people tell us, oh, I'm not being able to go retrieve my mail and things of that nature. And generally we were corresponding by mail. So how to be flexible We have a lot of privacy restrictions because our hearings are not public. So
Mhm.
we have to make sure that we're maintaining people's privacy. So can we send people stuff via email? Can we use encrypted email? All of these things, we always have to be willing to work and change and do so rapidly. And I think that's been the biggest thing that we've learned is you have to be willing to work on things and do it quickly to make sure that it works for people.
Thank you for that. I'm sure there's going to be questions that will flow from that, but I would say, Andrew, interesting that you have a fairly high number of 40% of in-person people, because we've always felt that even when we design our virtual services, that technology should not be a hurdle, and yet it's still seen as the big tool that many institutions and organizations have relied on just to get around.
Mhm.
Now, that said, there are two particular groups of people that we assist that I wanted to sort of discuss with you. One are those who just cannot use a computer. And I don't presume that that 40% staff that you shared with us, that they are all like that. But in the past, the way we got around it is, of course, we relied on trusted public intermediaries like public libraries, where they could go in there and file and get to you. That's not available these days. So what accommodations have you made to get those who cannot use a computer to still transact with you?
Sure. So, I mean, that's actually not a new accommodation for us. We know that there is a percentage of the population who either don't have access to computers, as you just mentioned, and those are the people who would normally go to the public library, for example, or simply just don't have the ability to use it. But those people are out there, and we understand that. You can always phone our organization, and that's one of the things that we have on all of our forms, and we've always had on all of our forms. If you're having trouble with this, phone us. You get to talk to a person. They'll understand if you're trying to file a notice of appeal. You just have to tell them what your name is, what your review division decision, so that's the lower level decision, give us that information. We will complete those portions of the form for you and mail it to you. So you just need to finish the notice of appeal by mailing it back to us with your reason for wanting an appeal. So I want more money, for example. But we'll do that first step for you. We've always done that. So that's not a change for us, but we'll continue to do it throughout this pandemic.
Did you have to staff up more just to be able to do this, or have you maintained sort of a regular number of support staff to handle this?
We've retained the same number of support staff. Many of our staff are now working at home, of course, as with most during this period of time, but we've continued to operate as normal throughout the pandemic, other than no in-person hearings, which we've been doing via teleconference for the last couple of months. Our staff are used to receiving these inquiries and taking those steps and sending out forms for people. These are the steps that we're used to taking, so it's not a big change for us in that respect. So nothing new from a staffing perspective for us. The last 2 months, for example, in April, that was our busiest intake month in the last 6 months. So we know that we're busy, but it's not an overwhelming jump yet. So we can handle it at this time.
And hearings wise?
So hearings wise, what we've been doing is we had hearings, of course, scheduled throughout March, April, May, and now coming into June. Those are all supposed to be in-person hearings. And we hold hearings throughout the province. So we'll travel to various areas in the province and come to you. We rent meeting rooms and we'll hold hearings there. So the change for us is there is no travel essentially right now, and there are no in-person hearings right now. We contacted every person who had a hearing with us that was scheduled, asked them if they would transition it to a telephone conference. Most people agreed to that. Some people objected, saying they wanted the in-person type of hearing. Starting on June 1st, so next week, and we've done a couple already, we're going to be doing video conferencing to hopefully alleviate some of that issue. But as you mentioned earlier, there are those who are not comfortable using a computer. Some people don't have even a smartphone. So if it comes down to it and we still need to have in-person hearings, we'll do it. We'll need to find the appropriate accommodations in order to preserve everybody's health and safety, and we're developing that process right now. Our goal is to do most, if not all, of the hearings via video conference, because you can still see each other, you can still relate to each other. There is that personal interaction that you perhaps don't get on the telephone. But that's the goal right now. But if we have to accommodate people, we will.
So just pushing the envelope just a little bit. What are your hours
Our hours of operation,
of hearings?
very, very regular government style hours of operation. So if you want to phone us and actually speak to a person, they will be answering their phones generally from 8:30 to 4:30. You will get phone calls from our staff outside of those hours, certainly. We've been more flexible with our staff because of various childcare issues and things of that nature. People are working different hours. So you might get phone calls on the weekend. You might get phone calls later in the day from us as well.
And the reason why I say I'm pushing it a little bit, because it's a question I've been asking the other interviewees, same question. Post-pandemic, sort of new normal, this is sort of the type of accommodations that maybe the public would appreciate in terms of sort of the, 8:30 to 4:30 hours with the occasional exceptional call. Has there been any consideration to providing sort of longer hours? And the other one, the other part to that question is to sort of consider asynchronous service where the parties involved, if they're agreeable to some type of special time, would you consider hosting that outside of your normal hours?
Sure. I think that if the need is there for people who simply cannot make a certain hearing time, whether it's a video conference hearing, a teleconference hearing, we can accommodate that. And certainly our members, our vice chairs who make the decisions in our appeals, because they're used to traveling around the province, they don't shut down hearings at 4:30 when they're out of town. If there's more evidence to come, we hear the evidence. So we're used to working at different times if that's necessary. And I think if we can't find a time for people, then of course that's something that we could look into. For the most part, we're giving people a significant degree of notice, and we hope that they're available at the time we set out for them. We give people the opportunity to tell us, I can't make that time. Can you please reschedule it within a 4-week period? And so we do that as well.
Thank you. That leads me to the second sort of question relating to technology. There's another subgroup, fairly significant and very special to our hearts at AC, victims of gender violence, who have a multitude of workplace issues. And because of the pandemic, they have no choice, but in some cases, to be in the same home as their abusive partner. So how do you go about sort of providing them privacy and safety when they are engaging with your tribunal?
Right, and that's one of the things that we ask people when we're asking them if they're available for video conference is, do you have a place where you can do it privately and safely? If people don't have that available to them, like I said earlier, we're willing to make accommodations, and we're willing to figure out a way, whether you come into our office and do the hearing in that fashion, we're willing to do that. With respect to specific issues relating to things like gender violence and violence in general in the workplace, we always ask parties, do they think they need a security officer present at a hearing? Obviously with video conference, that's not the same, but these are things that we ask already. So we take these things into account.
Right. I would imagine that the dynamics for teleconferencing, where everybody can see each other, takes a different lens when we're looking at victims of gendered violence, because it's possible that someone in the room may trigger trauma in that sense.
Right, and I think that those are issues that certainly the courts deal with on a very regular basis, and they've come up with ways to address that, whether it's not having witnesses in the room at the same time, things of that nature. And certainly our vice chairs, when they're conducting a video conference, are able to choose who's participating at what time as well.
Okay, that leads me to my third question. Did you have to triage sort of urgent, non-urgent? You kind of mentioned that your intake kind of got busy, not out of the ordinary level busy, but still busy. But did you have to sort of do some triage to determine what's more urgent, what's not, given deadlines and so on?
We haven't triaged anything with respect to urgency that's coming in as new. What we have done, because there were some people who we contacted who had an in-person hearing scheduled for March, April, and May and said they did not want to proceed by teleconference, and we accommodated that generally. So those people need their hearings to be rescheduled by video conference. So we are now prioritizing those hearings to make sure that they get heard in short order. But those are the only ones that have been, and I wouldn't call it delayed because they're still within their statutory time frame, but they have been, their hearing has been pushed back. But otherwise, everything is as normal for us.
Okay. What percentage of applicants are self-represented with your tribunal?
So at our tribunal, for worker appellants, which is about 85% of our appeals are appeals from workers, approximately 60% of those are represented. Employers are also entitled to participate in appeals, and around 80% of employers are represented.
Okay. So for those who are self-represented, what does the tribunal do with respect to trying to level the playing field, so to speak, in terms of procedural fairness, transparency, and whatever accommodations that might be available?
Sure. Well, I think that for our tribunal, we're used to having self-represented people. It's not a new phenomenon. The numbers have been ticking up over the last few years, but it's not something that's entirely new. So obviously we do the usual things such as providing user guides for people on our website and things of that nature, explaining to people what a hearing is going to look like, how you might want to gather evidence for your hearing, how you would go about getting evidence, things of that nature. But we also, every appeal at our tribunal has an appeal coordinator. So that's the person who's doing the scheduling, sending out the letters saying you need to gather your evidence by this date. Those folks provide their direct phone number on every letter. You can phone them, you can talk to them, each and every one of them. So that's the starting point. For people, we've been focusing in the last year, we've been trying to come up with a program for those who are historically disadvantaged in the justice system. We started off by asking people who are Indigenous to self-identify on our notices of appeal. If they do so, we have a position at our tribunal called a Navigator, whose job is to help people get through our processes. So we started that in May of 2019, and we've been working through that for the past year, helping people in that regard. If it works out well, so far the feedback is good. We think we can expand it to other areas where people would struggle with the processes. So people who have mental disorders, people who have perhaps gone through gendered violence, things of that nature. And
this Navigator is a live human being.
Yes.
It's not like, what do you call them? I see them, they're kind of like, they use artificial intelligence.
Oh, the clicks on the website. No, it's not that. You phone and you actually, if you say on your notice of appeal form that you would like to speak to a Navigator, we phone you. So we reach out first.
Okay, so tell me more about your other client-centered services, because this is amazing. It's the first that I've heard that you actually have a person who does one thing, which is to just navigate your tribunal.
Right, so we started that, and as I said, we started it with this particular group of people who are self-identifying as Indigenous. So our focus there has been, we know that there is a certain group of people who have generally struggled with the justice system. So let's see if we can help make that process smoother for them. And as I said, if it's going well and we can roll it out more, we'd like to do that. I think we're fortunate in the workers' compensation system as well. That there are, under the statute, the Workers' Advisor's Office and the Employer's Advisor's Office who are available to provide advice and assistance and representation to either workers or employers for free. That's a free service that the government provides. And so we, of course, refer people to those services on a regular basis because that's what they're there to provide. But like I said, I think from a client-centered perspective, our goal is to A, have actual live people you can talk to, and B, make sure that things proceed in a straightforward and rather quick manner so that we can get you to the end of your appeal.
Okay, thank you. I love that. Now, that leads me to my final question. Given the majority of the people that appear before your tribunal are still represented by lawyers, a very powerful group of insiders. I like to say that because they have bar associations, subsections, and through our regulator, they're able to have that conversation. And I noticed that during this time, I guess the last 2 months, the amount of collaboration between the different institutions was pretty obvious. And good on them, because we needed that just to sort of triage our way through the early weeks of the pandemic. But if I was a self-represented person, if I was just an average person, how do I reach you? How do I continue to stay engaged with my matter with a tribunal beyond okay, we have the case manager. Is there anything else that's available to me?
Sure. Well, I think, I'll just start with the lawyer aspect of that question. Our system, the workers' compensation system, is a little bit different in that regard, in the sense that the Workers' Compensation Act carves out an exception for people, lay people, anyone can represent someone before our tribunal. You don't have to be a lawyer at all. And that exception is clearly carved out. And in fact, a lot of who we see are people representing their family members, colleagues representing their colleagues, union advocates representing people, and compensation consultants. And even from our perspective at the tribunal, yes, we have a lot of lawyers who are tribunal members, but we also have a lot of non-lawyers who are tribunal members. So we are a bit less lawyer focused than perhaps some other areas of the justice system. With respect to remaining connected, I mean, obviously we have the usual things, the website, and yes, you can phone someone and call. But I think another aspect of our system in workers' compensation that's a little bit different is that our appeal system is a hybrid model. So it's not strictly adversarial. Yes, the employers can come to a workers' appeal and ask questions, and they can bring evidence. But there is an inquiry aspect to the model as well. So when you come before our tribunal, and I hope people know this, and we do put it in our rules and everything of that nature, but if we think that there is evidence that our tribunal needs to gather in order to get to a full and fair decision on your appeal, we'll get it. So we will order an independent health examination. We will order WorkSafeBC to do a further investigation of your workplace. We do that kind of thing on a regular basis. I mean, at any given time, 10% of our appeals are in some sort of form of that further investigation. So, I mean, unless you actually come to the tribunal, you probably don't feel that level of connection. But I hope that once you're here, you do get that from us. And I think we try to make that very clear to people.
Well, it is indeed very assuring, Andrew. And I'm very glad we had this opportunity to have this conversation. Earlier on off camera, I said, I resist the temptation to compare one institution to the next, and I will hold myself to that. But what I did want to do as the final piece, of course, is to provide you sort of final words that you want, that you might want to convey to our viewers. So all yours, Andrew.
Thanks. So I think the main thing that I would say to people is that we're open, of course, and we're available to assist you. And if you are having any trouble completing a form, getting a submission in on time, gathering your evidence in a timely manner, phone us, let us know, email us, let us know, and we can make accommodations for all of those things. We've told people, and we put it on our website, if you're needing more time to make submissions or to do things like gather evidence, maybe you can't see your doctor, you can't see your kinesiologist or physiotherapist and get a medical report. We understand that during this time. Obviously, it's very difficult for everybody to see many people. So as long as you let us know, we'll be accommodating in that regard. We still want to get things done quickly for people because we want to get people the resolution to their appeal. But we know that things are a little bit difficult right now for many of us, and we're willing to be accommodating in that regard.
Thank you very much, Andrew. On
you,
that note, please, we want to extend our warm wishes to you and your colleagues to stay safe. And thank you for this opportunity to have this conversation, Andrew.
Thanks very much, and same to you.
All right. Well, be well.
Bye-bye.
Bye-bye.